Audit. Audit is done by auditors. Auditors verify the accuracy of financial statements. So company keeps the financial record and then auditors verify the accuracy. 139 talks about appointment of auditors. 139.1 talks about an individual or firm. An individual or firm may be auditor. Now, while dealing with the qualifications, we'll deal that they are required to be independent because nature of the task requires the same also. So, an individual or firm to be auditor appointed at first AGM. AGM means annual general meeting. And notice of such appointment is to be given to registrar within 15 days. And he hold office till conclusion of 6th AGM. Thereafter till conclusion of every 6th AGM or as provided. Now written consent is required that he wants to be auditor and declaration as to his eligibility. So section 141 will deal with it. Term of the appointment. 139 clause 2 talks about the terms of the appointment. It says no appointment or reappointment of individual auditor or firm would be there on completion of. So in case of individual auditor, on completion of one term of consecutive 5 years, okay, and in case of firm, on completion of 2 terms of consecutive 5 years, no appointment or reappointment will be there, but they may be reappointed after completion of 5 years from expiry of such terms. So after this one term of consecutive 5 years and then expiry of 5 years, they can be reappointed. Now the same applies to other auditor partner of same firm. For example, in this firm there is this partner, okay, applies to other audit partner of same firm, and then there is partner in this firm, so this restriction will apply on that partner also. Then rotation. 139 clause 3 talks about rotation. It says company may resolve to rotation for auditor and his team, or audit may be done by more than one auditor. So they may go for rotation, auditor and his team, and they may also resolve that audit may be done by more than one auditor. It gives much clarity to the financial statement, and it's kind of good practice that you may have 2 or 3 auditors at least. Then 139 clause 6 and read with 139 clause 1. They are talking about first auditor. Okay, they say from date of registration within 30 days board will appoint auditor. If board fails, then within 90 days member of the company will appoint auditor at EGM, extraordinary general meeting. We'll do it while we'll do the topic of meetings. Then we'll do extraordinary general meeting, and such auditor will hold office till conclusion of first AGM. Then 135 clause 5 read with 135 clause 7 talks about auditor in case of government company. So Comptroller and Auditor General of India, CAG, will appoint auditor within 180 days of financial year, and such auditor will hold office till conclusion of next AGM. So it will be in respect of the particular financial year. In case of first auditor, from date of registration within 60 days, CAG has to appoint. If CAG fails, then in next 30 days, Board of Director has to appoint. If Board of Director also fails to appoint the auditor, then within 60 days, member of the company will appoint auditor at EGM, extraordinary general meeting. Now in case of casual vacancy, 139 clause 8, if auditing has to be done by CAG, then within 30 days of the vacancy, CAG has to appoint. If CAG fails to appoint, then within next 30 days, board will appoint the casual vacancy. And if audit is not to be done by CAG, then within 30 days of the vacancy, Board of Directors is required to appoint. And if vacancy arises due to resignation, so appointment to be approved in general meeting within 3 months of recommendation by the board. If vacancies has arisen due to the resignation, then appointment of the new auditor will be approved in general meeting within 3 months of the recommendation of board. Then appointment of retiring auditor. So a retiring auditor may be reappointed at an AGM, annual general meeting. How? If he is not disqualified, he has not informed his unwillingness to be an auditor, means he has not said that he don't want to be an auditor, neither he is disqualified, and nor any resolution, special resolution has been passed against him that he should not be reappointed. If these conditions are there, then retiring auditor may be reappointed. Then audit committee. 139 clause 11 talks about audit committee. If audit committee is required to be formed as per section 177, then all appointment including casual vacancies to be done as per recommendation of such committee. Now 177 talks about requirement of audit committee, and the appointment, casual vacancy, everything they will be done by the recommendation of such committee. And these committees, they work with board of directors, but they may have that independent functioning also. Now eligibility, qualification and disqualification of creditors. Okay, so who can be creditor? Only if he is CA, chartered accountant, only then he can be creditor. Now the following persons shall not be eligible for appointment as an auditor, namely these people are not eligible to be appointed as an auditor: body corporate other than LLP, limited liability partnership, an officer or employee of the company. These are self-explanatory and you need to learn them. A person who is a partner or who is in employment of an officer or employee of the company. So if person who is a partner who is in employment with the company, he cannot be an auditor. A person who or his relative or partner is holding any security or interest in the company, okay, is indebted to the company, or has given a guarantee or provided security in connection with the indebtedness of the third person to the company. It includes company, subsidiary company, holding company, associate company, or subsidiary company of such holding company. All these 1, 2, 3 they cover. So if any such scenario is there by this person or his relative or partner, he cannot be auditor. Now a person or a firm who, whether directly or indirectly, has business relationship with the company. So person or firm having direct or indirect business relationship with the company cannot be an auditor. A person whose relative is a director or is in employment with the company as a director or key managerial person, then he cannot be an auditor. A person who is in full-time employment elsewhere, okay, or a person or partner of the firm holding appointment as auditor, he is full-time employment or full-time auditor at some other place, he cannot be. Then a person who has been convicted by court for an offence involving fraud and a period of 10 years has not elapsed from such conviction. And a person who directly indirectly render any service referred to in 144 to the company will not be an auditor. Now 144, what services? Let's go with 144. 144 takes out auditor not to render certain services. Okay, it says services as are approved by board of director or audit committee, only these services are to be provided, but these shall not include the following services: accounting and bookkeeping service, internal audit, design and implementation of financial information system, actuarial service, investment advisory service, investment banking services, rendering of outsourced financial servicing, management servicing, and any kind of service as may be prescribed. If these services are there, then he cannot be appointed as an auditor. Now powers and duties of auditors. Okay, what are his power and duties? Every auditor of a company shall have a right to access at all time to the book of account and voucher of the company. Now duties as auditor and amongst other matter, okay, he can inquire into the following matter. So this is his duty. Inquiring in these matter also part and parcel of his duty. What are those matter? Whether loan and advance made by the company on the basis of security have been properly secured or not. Okay, so loan and advance you have made, so have you taken security for that, or you have done that on the basis of credit history? Then whether transactions of the company which are represented merely by book entries are prejudicial to the interest of the company or not. So there are transactions which have been represented merely by book entries, so it affects the interest of the company or not. Then where the company not being investment company or banking company, okay, so company not being investment or banking company, so their securities has been sold, their share debentures or the securities has been sold at a price less than at which they were purchased. Whether loan and advance made by the company have been shown as deposit or not. Whether personal expenses have been charged to revenue account or not. So he will look into these matters. It is his duty, and these things seems to be small, but by virtue of these portals many times a large amount have been channelized. Now auditor's report shall also to state what, whether he has sought and obtained all the information and explanation. So whether he has received all the information, all the explanation required to make the auditing report, he will mention that. If he has received as per his satisfaction, he will write it. If he has not received, he may write. It may act as remark, which we have studied earlier, the remarks by the auditor or CS, as the case may be. It may fall there. Then whether in his opinion proper books of account as required by law has been kept by the company or not. So whether company is keeping proper account book as per the law, the report shall include this fact also. Whether report on account of any branch office of the company, he will mention the same. Whether the company's balance sheet and profit and loss account dealt within the report are in agreement with books of account and returns. Okay, you have your books of account and return, then you create a balance sheet. All that has to be consistent with each other. If there is difference, even of 1 rupee is difference, it means there is some error is there, either some wrong entry is there or some clerical error is there. Whether in his opinion the financial statement comply with the accounting standards or not. Accounting standards have to be compliant. Then observation or comment of the auditors on financial transactions which may adversely affect the functioning of the company, or whether a director is disqualified. Again, these are self-explanatory and you need to learn them. Any qualification, reservation or adverse remark relating to maintenance of account and other matters connected herewith. So these things have to be mentioned in the report. Whether company has adequate internal financing control or not, okay, and such other matters as may be prescribed. So these are the provisions, important provisions related to audit.